let's look at the legal position. Sanjay Hegde, Advocate, Supreme Court, joining us. Tanveer Ahmed MIR, Senior Advocate, Supreme Court. Aryama Sundaram, Senior Advocate, Supreme Court. And Professor Vishwambar Mishra, who is from Banaras and has been involved with the IIT BHU and also, of course, there with the Sankat Mochan Temple. Appreciate all of you joining us. I want to come to each of you to understand this act. Do you believe, you heard Mr. Asaduddin Owaisi saying just now, Sanjay Hegde, that the Places of Worship Act is supreme. You cannot touch an existing structure. The only exception was made for Ayodhya. Today you allow a survey in Varanasi, it will open the floodgates. Does that argument hold, or has the situation qualitatively changed between 91 and 2022?
Well, the Act of 91 still remains on the statute book. And Mr. Owaisi refers to the Supreme Court judgment in the Ayodhya case, which said that this Act has been upheld and is part of secularism. Parliament took a conscious decision immediately in 1991. Parliament can yet take a decision maybe to abolish this Act altogether, but that has not so far happened. So any religious structure in place on August 15th, 1947 shall continue to have the same character. That is what Parliament has decided.
No, but the lower court, but Mr. Hegde, the lower court, by allowing the survey, has already effectively suggested that the Parliament, that the Act of 1991, in a sense, no longer clearly has gone beyond the 1991 Act, made an exception then.
See, the point is that it's a civil suit. The lower court should have possibly thrown out the civil suit at the first instance. It has not done so. Now it has allowed the suit to proceed, and it is in the process of allowing certain applications in order to bring some evidence on record. The court had appointed a commissioner to conduct a survey. There were doubts raised about the commissioner. Now the court today has added 2 more commissioners to aid the original commissioner. The interim order was challenged in the High Court. The High Court refused to interfere with the earlier interim order. That matter was not carried up further in appeal to the Supreme Court. If and when the matter reaches the Supreme Court in some form, we would have to see. Mr. Owaisi has asked a valid question. If at the end you can grant no relief, because every religious structure has to remain the same way as it was in 1947, then why do you proceed with the suit at all? That and other questions may have to be taken to a larger,
so you're
higher
saying
court.
You will have to take this to a higher court, but Tanveer Ahmed MIR, in the first instance, do you believe that the petitioners have won their first round and therefore the Gyanvapi Mosque management is now in a predicament? Either they go and appeal right away to a higher court, or they will have to open the mosque, and that could lead to further repercussions.
Well, Rajdeep, that's absolutely correct. The order passed by the court concerned in Varanasi certainly is beyond the parameters of 1991 Act. And since the court has passed an order to the detriment of one party, it is now obligatory on the other party to take this matter up and bring it to the notice of the appellate authorities or the revising authorities in the High Court, or even straight away petition the matter under 136 to Honorable Supreme Court of India and bring it to the notice of the Supreme Court that what is going on is totally impermissible. This cannot be done at all. This is beyond the Act, beyond the legislature. It is also in violation of the preamble of the Constitution of India. At the end of the day, the religious places as they existed in 1947 is a part of Indian ethics and Indian ethos. Whether it is a temple or a mosque, it belongs to every Indian, irrespective of what community and the religious spiritualism that he believes in. Therefore, I believe that there are very strong political forces operating on the ground zero, intending to spread communal poison. And the 1991 Act perhaps was brought and indisputably brought by the government then in power to kill this poison. Unfortunately, what we are seeing over all these times is that there are now so many manifestations to keep the communal pot boiling. Therefore, it is an incumbent responsibility on every Indian to oppose all such moves.
But let me, Aryama Sundaram, read out what the suit argues. The suit argues that the illegal actions of invaders cannot be legalized by Parliament through this Places of Worship Act, as it infringes upon the religious rights of Hindus guaranteed under Article 25 of the Constitution. It argues that Hindu devotees cannot be prohibited by Parliament from getting back their religious place of worship through the judicial route. Do you believe, therefore, that the act itself is now being challenged in a way, Aryama Sundaram, and is that a valid challenge?
Look, let's understand three things here. Number one, there is a statute. And that statute is in force. And that statute makes it very clear that apart from the Gyanvapi Masjid, Ayodhya issue, all other places of religious worship, the status quo as in 1947 shall be maintained. That is the statute. That statute has been noticed, recognized, and approved by a subsequent judgment of the Supreme Court. Chief Justice, as he then was, himself said. That's number two. Number three, the suit has been filed as a civil suit. It is not a writ petition challenging the virus of the Act. It is not a petition challenging the constitutionality of the Act or otherwise. The suit has been filed for a relief of restoration of the temple there. Now, as the Act stands, that suit cannot really be proceeded with. On the one hand, one may say that an interim order of court granted for the ASI to do it as a fact-finding issue itself, how can it be permissible? But we must remember that any interim order has to be a step in aid of the final decision of the suit. And if the final decision of the suit is towards restoration of the temple, and that can't be granted under the Act, then any interim order towards that end can equally not be passed.
No, so are you saying, Aryama Sundaram, are you saying therefore that the Act, are you saying the Act, that's exactly, are you saying that the Act has to be amended, that has to take place through a parliamentary route, and therefore the judicial route is very limited, am I correct?
The judicial route can at best be for a court exercising its extraordinary jurisdiction, writ jurisdiction, Article 226, to see the virus of the Act, to see whether the Act is constitutional, not constitutional, and looking at the legality of the Act itself. But in a suit filed, inter partes suit, filed for the purpose of restoration of a temple, the Act holds the field. And as long as that Act holds the field and is not amended, nothing contrary to the Act can be done in a civil suit.
Does it stop a survey? No, Mr. Aryama Sundaram, does it stop a survey? The Act prevents the religious character being changed. But does it stop a survey?
Good question, Rajdeep. A survey, like I said, being conducted as a fact-finding issue perhaps cannot be found fault with. The government can always order a survey if the government wants. But can it be by way of an interim order in a suit which itself cannot get the relief of restoration as a temple because it's barred by the Act? And if your final relief is that, then this cannot be used as a step in aid of a final relief which cannot be got. And if you cannot, because of the Act, restore it to a temple, then an interim order, which is an interim order can only be an order which is towards the resolution of the final dispute. An interim order cannot be an abstract of saying, look, I think it's a good idea, the ASI goes and investigates the matter. That is not an issue at all. Any interim order will have to be a step in aid for the decision of the suit. And so the interim order here given is a step in aid in decision of a suit which final relief appears as the law stands today until amendment to be barred.
Okay, let me for a moment.
Therefore, the interim order,
you've made your point,
cannot be passed in such a suit.
Okay, you made your point that an interim order cannot be passed in such a suit because at some stage it comes, at least for now, in violation of the Places of Worship Act. But Vishwambar Mishra, this is not just a legal battle. You are there in Varanasi, you been dealing with many temple trusts there. This is a political battle also. And somewhere down the line, do you think, Professor Mishra, that politics is taking over now? This is not about what the law is. This is about somebody saying आस्था, faith. मेरी आस्था है कि वहाँ मंदिर है, मुझे अधिकार होना चाहिए वहाँ जाकर पूजा करने के लिए. That this is all coming down to politics, to the entire issue of faith. Faith above law. Law कानून छोड़िए, आस्था comes above law.
Rajdeep ji, this country is run by a well-formulated constitution. And I think everybody should have Astha for the constitution, and whatever was formulated in 1947, I think that should be respected. Now, if you start making a survey, now survey at till what depth? Suppose if you are making a survey up to say 10 to 20 feet, then why don't you go beyond that? And see, depth also has to be defined. But this is not the way. If you start, because you have other important issues which are not being addressed. For example, if you talk about education policy, economic condition of the country, job opportunity for the youngs. So these have been set apart.
No, these are there, but Professor Mishra, there are people in Varanasi who say all that is well. हमारी आस्था का सवाल है. There are
नहीं आस्था, देखिए जान बचेगी तो सब आस्था भी रहेगा, ऐसा नहीं है. अभी आपके पास जो ये आपका इन्फ्लेशन का है, ये सब चीजें आप अगर नहीं एड्रेस कर पाएंगे, we are gradually moving towards an end which cannot be reversed. और ऐसे नहीं होता. And see, whatever path you are adopting, this is an endless path, and it can never be formulated on these lines.
No, so are you saying that the majority of people in Varanasi would rather that this issue be settled amicably rather than through some kind of force?
No, I think if it is settled amicably, that is the finest way, and that is the right approach. But I think deliberately a scene is being created with some interest. I don't know what is the interest, and I think we are moving in a path which we cannot backtrace again. So this is very unfortunate, and most of the people, they are just simply mute observers. And I don't know for what reason they are not opening their mouth.
You know, you're saying they are mute observers, but you know, Sanjay Hegde, I come back to it. Faith above law. We saw that even in the initial period of the Ayodhya movement, that this is a matter of astha. Don't bring the law into it. In a sense, does this reveal the limits of the law? The Places of Worship Act was brought in after the demolition, and there was a sense that it was needed at the time. 31 years later, the BJP, the party which led the agitation for Ram Janmabhoomi, is in power. They've always said, after Ayodhya, Kashi, Mathura. So in a sense, you're seeing politics trumping the law.
Yes, the slogan always has been, Ayodhya to bas jhaki hai, Kashi Mathura baki hai, teen nahi, ab 30,000 nahi bachegi koi mazar. All kinds of things have been said. But to correct you, the Act of 1991 was passed before the demolition of 1992.
My correction, yes.
And despite the demolition, Parliament has reaffirmed itself as far as this Act is concerned. Several parliaments have come and gone. Nobody has interfered. The courts have commended the Act. This was a national consensus that Ayodhya was to be treated as a one-off.
Correct.
That there was a movement and all that. Let us begin and end with Ayodhya. If you want to continue this now into Kashi, then into Mathura, and all over the place, we will not be a country much better than the Taliban who destroyed the Bamiyan Buddhas. Everything is part of our history. Everything is part of our history. There may be some parts of our history which some sections of our populace may be uncomfortable with. But the answer is to do things which are historical, which will have their own impact in the future. It is not to go back to the past and rewrite.
Sure,
this kind of attempt has to be shut down at the earliest.
But given the way society has got polarized on these issues, Tanveer Ahmed MIR, do you see a possibility of an out-of-court settlement, or are these, by their very nature now, going to result in, as I call them, weapons of mass distraction, but that they are designed in a way to create an environment which pits one community against the other?
Well, Rajdeep, it's a matter of political resolve. If the political objective philosophy of a particular political dispensation is based on the philosophy of polarization, then every step which aids ultimately the electoral benefit will be certainly taken by the political party. It is up to us, the Indian citizens. Let me tell you that, in India, as we citizens are and we understand, even referring somebody to as majority and minority is an insult to Indianness. It is up to the silent majority, each person, irrespective of his religious beliefs, to put his foot down. Because ultimately, the people will give the answer in the larger interest.
Okay.
If you shun the political parties who are pursuing this path of destruction, polarization, and putting people brothers against brothers, well then you're going to see the results, and that they're going to be catastrophic. As far as we are concerned, we understand that we are a political democracy, socialist, secular. At the end of the day, the word secular in the 42nd Amendment of the Indian Constitution was brought for a particular purpose. That is that every Indian, irrespective of his religious belief, should have the right to live his life with dignity.
Well, that is exactly which is being used.
Monument, it should be respected.
That is exactly, though Article 25 in itself, freedom to practice religion, is now being used in cases like this to, in a way, reclaim what some Hindus are saying is their civilizational heritage, and potentially, therefore, you have another friction point emerging, this time in Varanasi. Whether that falls within the Places of Worship Act is a matter that possibly now a higher court will have to decide. But we again have a potential trigger that could once again lead to division on the ground. Let me leave it there at the moment. I appreciate my guests joining me here on my top talking point on the news today.